Earlier, you were on another network and you said it's true, in agreement you need the signature of both parties, and if there's no signature by him, it's not valid.
Well, I have to acknowledge that I was incorrect. A study of the patent jury instructions were given to all judges to guide them in what they should do. Makes clear that even though the signature was not there, if she took the money and acted in a way to waive his signature because she took the money, then she can't have it both ways. She can't take the money and then claim the agreement was invalid. As I told you, I have the leading case on the subject.
Let me ask you, I'm going to go on, but what if she forfeits the money? Still, it is legal and binding?
No, the agreement, the conduct spells out a waiver of the need for him to sign the agreement. It spells out her condoning the fact that he didn't need to sign the agreement. Unless the agreement says itself that it doesn't become binding unless it's signed by the party, he can rely on the doctrine of waiver, estoppel. It means just what it sounds like. You can't assert a right if you are take a benefit.
You told me that you don't believe she has a case. You think she'll lose this case?
She'll lose the case without question.
Why so?
Because these agreements are upheld. A party can waive the First Amendment rights, they can waive the Fourth Amendment, the Fifth Amendment. Constitutional rights can be waived. And she chose to sign the document, take the money, and run. To use Woody Allen's expression,
perhaps
took the money and run.
If she had waited for his signature, for the execution of his signature, then maybe she might have a case. But she didn't.
She wouldn't have.
She acted as if that the agreement was valid.
Valid.
Correct?
If he allegedly signed it, then she would be clearly out of court. And that's what the appellate division held and the Court of Appeals.
You said that you had the leading case in New York.
Yes.
In regards to?
Yes, in regards to the enforceability of a non-disclosure agreement. It went to the appellate division, and the Court of Appeals refused to review the decision of the appellate division. It's a reported case, and it stands for the proposition that these agreements are enforceable. Now, conduct is also a great moment, and she took the benefits of the agreement and now claims that there was no agreement because he didn't sign it. Assuming her story is correct that he was involved with her, I don't know whether that's
true. Said that you just now said that you were wrong after your initial appearance this morning. Did you speak with anyone?
No, I consulted, and I still have it here for you, the patent jury instructions. I have the pages for you. This lays out what the law is, and all judges in the state have to comply with the patent jury instructions. And there's no question, it's 100-0 that she would lose.
If you were advising Stormy Daniels now, what would you advise her, Mr. Goldberg? What would you say to her?
She can't give the money back because she wouldn't give the money back. I mean, she's off on a tour and attempting to profit from the great deal of publicity. I wonder whether her story is correct. The fact that she has a picture with Trump means nothing to me. People have pictures standing next to politicians all the time, or people of note, and that doesn't prove her case.
The payment of the admitted payment of $130,000 in the arbitration, that doesn't mean anything?
Well, I'd have to speak to Cohn on that, and I haven't done that. All I'm here to tell you is that her taking of the money condones the lack of a signature. The agreement doesn't say it doesn't become valid until he signs it. It doesn't say that. And these agreements are like written in cement. They are upheld all the time in New York. And I was mistaken when I said to the contrary.
Well, let me ask you something. With the whole, what's happening now with Me Too movement, there is a discussion about these non-disclosure agreements.
Yes.
It is believed by some of the accusers and the people who are fighting for the women that it takes away their right to free speech. What do you say to that?
Well, the lower court, in the case that I was involved in, held that very same thing, that it impacted negatively on the right of free speech. But the appellate division held that a person can waive the right to free speech, can waive constitutional rights, the Fourth Amendment, the Fifth Amendment, and the like, and the court upheld it in the appellate division. And even the Court of Appeals, which is our highest court, refused to review it or disturb the holding below. These agreements are, and this is a situation that's an a fortiori case, taking the money, the benefits of the agreement, and then claiming the agreement is invalid. It's just, no judge would go for that. No jury would go for that.
Fascinating conversation. I appreciate your expertise. Thank you for coming in, Jay Goldberg.
All right. Good to see you.
Good to see you. Thank you very much.